discussion this morning, and this is part 2 of our discussion in non-institutional correction. So in our previous lesson, we discussed the different histories of probation from its original and historical setting. We discussed the different theories in punishing criminals, and of course the different forerunners of probation. We also discussed that correction is part of the criminal justice system of our country, and it is the fourth pillar of criminal justice system, which is in charge with reforming and rehabilitating offenders. In our country, we have two kinds of correction: the non-institutional correction and the non-institutional correction. Institutional correction is focusing on how to incarcerate offenders. In this type is we are putting or we are incarcerating criminals inside prison or inside jails. While in non-institutional correction, it is a reformation outside prison or outside jail, wherein the offenders are given the opportunity to reform, to rehabilitate together with his or her families. Now, we discussed also that death penalty was being abolished, and it was abolished on June 6, 2006 under the administration of former President Gloria Macapagal Arroyo. And with a majority of votes from the upper and the lower chamber of Congress, and for these reasons, death penalty in our country was being abolished. So they say that death penalty is retributive justice. It is an ultimate, cruel, and inhumane punishment. And of course, it is irrevocable. It shuts out rehabilitative justice. It raises the likelihood of criminals becoming more violent for fear of being convicted, and of course it is anti-poor. So in the abolition of the death penalty, non-institutional correction was strengthened, and the main focus and the main concentration of this correctional system is more on probation, parole, good conduct, time allowance, reprieve, suspension of sentence, and the like, and of course, the so-called amnesty. Now, in the history of probation, we learned that John Augustus was considered as the father of probation, not only in America but also in the whole world, because of his contribution. And he was also considered as the first official probation officer in America. And of course, Augustus' efforts are credited with the establishment of the pre-sentence investigation. Now, another personality is Matthew Davenport Hill. And Matthew Davenport Hill was considered as the father of probation in England because of his principle that one is individualized treatment, and individuals are not fully corrupt, and there is still a chance for them to be reformed or rehabilitated. Now, in the Philippine setting, the first law of probation is Act 4221, and we discussed that in our previous discussion. And under this law, it was enacted on August 7, 1935, but unfortunately, after 2 years of operation, on November 16, 1937, this law was declared unconstitutional by the Supreme Court under the case of People of the Philippines versus Judge Vera. And there are three reasons that were being raised. And one is, according to them, it encroaches the pardoning power of the executive. So that is number one reason. The second one is, I think, it violated the equal protections of the law. And number three is, it violates the legislative power of the legislature. So those are the three reasons why this law was being abolished, and it was declared unconstitutional by the Supreme Court. And from 1937 to 1976, there was no law that was being approved to cater and to strengthen or to establish again the probation system in the Philippines. And then in 1976, Presidential Decree 968 was being established, and this is the main law until today governing the system and the policy concerning probation system. And of course, it is also include the implementing rules and regulations. So PD 968 is the law establishing a probation system, appropriating funds therefore and for other purposes. It was enacted on July 24, 1976. So from 1937, since the time that Act 4221 was being declared unconstitutional by the Supreme Court, now in 1976, finally, Presidential Decree 968 was being enacted, and it was signed into law by President Ferdinand E. Marcos. So the probation system was started to operate on January 3, 1978, after 2 years since the time it was enacted. And finally, ito po ay nagsimula na mag-operate at i-implement ang probation system dito po sa Pilipinas. Now, in 1987, so from 1976 to 1987, it was being expanded through an implementing rules and regulations embodied in Section 23 to 25, Chapter 7, Title 3, Book 4 of the Executive Order 292, known as the Administrative Code of the Philippines. And ito po ay naging malinaw at naging posible because of Section 19, Paragraph D of Presidential Decree 968, wherein it says that in pursuance with his authority, according to the provisions of Section 19, promulgate, ano po ang sinasabi doon sa Section 19, paragraph D of Presidential Decree 968, states that the state shall promulgate subject to the approval of the Secretary of Justice the necessary rules relative to the methods and procedures of the probation process. Because of this provision of PD 968, then in 1987, it was expanded, nagkaroon siya ng implementing rules and regulation at ito ay ipinasok doon sa Administrative Code of the Philippines, also known as the Executive Order 292, nakapaloob doon. Under Section 23 to 25, Chapter 7, doon natin makikita yung implementing rules and regulation ng ating probation system. Now, under these implementing rules and regulations, it was known and cited as the Parole and Probation Administration Omnibus Rules on Probation Methods and Procedures. Yan po yung tawag sa IRR ng PD 968. And for brevity is probation rules or simply rules. So the IRR can also call the probation rules or simply rules. Yan po yung sinasabi dyan. And so under this rule, it says that it shall be liberally construed so as to successfully, efficiently, and effectively implement, carry out, and effectuate the social justice spirit, intent, and the rationale or the summary, the spirit and intent of the probation law. Okay? So, kung ating titignan, ang sabi dito, Sir, what if nagkaroon ng conflict between PD 968 and the IRR of this law? Ano ang magpiprevail? At ang sabi po dito, in the event of doubt or conflict, the spirit and intent of the probation law, which is the IRR, and these rules shall prevail over the letter or literal provision thereof, considering that they partake of social legislation and are special laws in nature and character. Okay, it will prevail. The IRR will prevail over the law itself in case there is a doubt, there is a conflict, okay, concerning these two. Okay. But fortunately, still, wala pa namang nagiging conflict. Now, let us first define what is probation. Probation is a disposition under which a defendant, after conviction and sentence, is released subject to conditions imposed by the court and to the supervision of a probation officer. It is a disposition after conviction and sentence. So meaning, ang probation ay applicable lamang sa mga offenders na merong final conviction. Okay? Hindi ito applicable sa mga offenders na wala pang final conviction coming from the court. Okay? And ang sabing ganon is released subject to conditions imposed. That's why it is a non-institutional based program wherein the offender or the inmate or the petitioner ay ibabalik sa community at hindi sila required na ikulong. Hindi sila required na mag-stay sa kulungan, but they will be released subject to the conditions imposed by the court and to the supervision of probation officer. It was John Augustus who coined the word probation, which he derived from the Latin word probare, which means to prove or to test. So, yan yun. Next, what are the different purposes of probation? I think we discussed that in our previous discussion, but let me repeat it again. In letter A, ang sabi po dito, one of the purpose is to promote the correction and rehabilitation of offenders by providing him with individualized treatment. Second, to provide an opportunity for the reformation. And thirdly, to prevent the commission of an offense. Now, the question is, what is the process, or what are the process to be observed in applying for probation until its termination? Ano-ano ba yung mga proseso? Paano mag-apply at hanggang kailan, at ano yung mga process hanggang sa ma-terminate or mag-stop ang service on probation? So yan yung mga titignan at pag-aaralan natin ngayong umagang ito. So number 1, concerning application for probation under Section 7 of Probation Rules. So probation rules is not the PD 968, but it is the implementing rules and regulations of probation. So probation rules. Under Section 7 of Probation Rules, an application for probation shall be filed with the trial court by a sentenced or convicted person within the period of perfecting an appeal. So yung period or yung period kung kailan o hanggang kailan pwedeng mag-file ng application ng petition ang offender for probation is only 15 days from the time of receipt of a copy of judgment of conviction. Okay? So, 15 days, gumagana na yan. Bibigyan ka ng korte ng 15 araw para ikaw ay mag-file ng iyong petition. Now, the 15-day period is due to the provision of the probation rules that the applicant shall file his application with the trial court at any time after conviction and sentence, but within the period for perfecting his appeal. So makikita natin dito, that's why probation is not a matter of rights wherein the government is obliged to provide or to give that program to you. No, hindi po ganun. Probation is a matter of privilege. Hindi mo pwedeng sabihin sa government na ikaw ay, qualified ako, ay pwede mo nang ibigay sa akin yung probation. No. It is only a matter of privilege, and the judge will decide whether your application is granted or it will be denied. So yan po yun. But you need to apply for probation. Okay? You need to apply for probation if you as an offender is qualified. But if not, then no need to apply for it. So ang sabi dito, the applicant shall file his application with the trial court at any time after conviction and sentence, but within the period for perfecting his appeal. Now, The right to file an appeal and the right to apply for probation are exercised in the alternative. Meaning, kung ikaw ay nag-apply na ng appeal, hindi ka na pwedeng mag-apply for probation. Pag nag-apply ka for probation, ay hindi ka na pwedeng mag-apply for an appeal. So lahat ng yan ay mamimili ka within 15 days. If you choose to elevate your case to the higher authorities, then wini-waive mo yung rights mo na mag-apply for probation. An order granting or denying probation shall not be appealable in Section 4, PD 968, wherein, let's say, nag-file ka ngayon at dininayan ng korte at gusto mong mag-apply ulit, hindi na pwede. Application for probation is only once. Pag na-deny yan, hindi na pwede. Okay? Hindi mo pwedeng i-appeal sa mas mataas na korte dahil yan ay once mo lang pwedeng gawin. Now, under Section 1, RA 1077, 10707. Ano itong batas na ito? Itong batas na ito ay na-approve noong 2015 to amend certain provisions of PD 968. So meron ng bagong batas. But ina-amend niya lang yung ilang mga provision ng Presidential Decree 968. So hindi niya totally binago, hindi niya ni-repeal ang old law, but there are some provisions that was made change. And ang sabi ganon, Republic Act 1077 is an act amending Presidential Decree number 968, otherwise known as the Probation Law of 1976 as amended. Now, ano yung binago? Ang binago dito ay ang sabi sa batas na ito, kapag ka ang isang tao ay na-convict at yung years of imprisonment niya ay disqualified sa provision para ang isang offender ay ma-qualify for probation. Let's say, ang kanyang years of imprisonment is 8 years or 9 years. Supposed to be, yung offender na yan ay disqualified na. Kasi ang maximum lamang na years of imprisonment for the offender to be qualified is only 6 years and below. Ang problema, naging 9 years. Now, siya ngayon ay nag-apply ng appeal sa mas mataas na korte at lumabas yung result at yung kaso niya ngayon, yung years of imprisonment niya ay na-mitigate, bumaba. At nag-fall doon sa years of imprisonment that is below 6 years. So kung titingnan natin, pasok siya sa qualification. But unfortunately, sa old law, siya ay disqualified kasi in the first place, pinili niya na mag-appeal. And at the same time, mas mataas ang kanyang penalty before. Now, ang sabi ng batas na ito, 1070 and 7. In case ng isang tao, offender, ay nag-appeal at ang kanyang years of imprisonment ay pumasok doon sa qualification para siya ay makapag-apply ng probation, then he or she was allowed to apply for probation. He is now allowed to apply for probation under Section 1 of Republic Act 1070 verse 7. So, nagkaroon ng changes. Okay? Sa PD 968, pag ikaw ay nag-apply ng appeal, hindi ka na pwedeng mag-apply for probation. If more than 6 years ang imprisonment mo, you are disqualified. But under this law, in case na mas higher ang iyong penalty and it is beyond 6 years and then you apply for an appeal at ang sabi ng higher court na nabawasan ang iyong years of imprisonment at pumasok siya sa qualification of years, then you are allowed to apply for probation. This inmate, this offender is now allowed to apply for probation. So yan yung mga nabago under Republic Act 1070 and 7. Now, what if a convict neither appealed nor applied for probation? Then the answer is, hindi na siya pwedeng gumawa pa ng any remedy dahil ang kanyang penalty, ang kanyang judgment of conviction will become final and he will serve the original sentence, his original sentence. He will serve that. So yun yung halimbawa, lumipas ang 15 days. Hindi siya nag-appeal, hindi siya nag-apply for probation, then magiging final ang kanyang conviction and he will serve his original sentence inside prison. Okay? So yun yung mangyayari, consequences. Are all convicts qualified to apply for probation? Are all convicts qualified to apply for probation? The answer is no. Hindi lahat, dahil merong mga qualification at merong mga disqualification. So the following are the disqualification in applying probation under Section 9 of Presidential Decree 968. Ay ito yung mga disqualification. Number 1, those sentenced to serve a maximum term of imprisonment of more than 6 years. Yun yung kwento natin kanina. But under the new law, in case na siya ay nag-appeal at bumaba ang kanyang kaso at pumasok sa 6 years and below, then he will allowed and he is qualified to apply for probation. Second, those convicted of any offense against the security of the state. Pag sinabi natin against the security of the state, these are the crimes against national security or crimes against public orders. Ano itong mga ito? Number 1, rebellion or insurrection, Article 134 of the Revised Penal Code. Kudeta under Article 134, Paragraph A of the Revised Penal Code. Disloyalty of public officers or employees under Article 137 of the Revised Penal Code. Pagka ito ang krimen na nagawa nila, they are disqualified to apply for probation. Sedition under Article 139 of the Revised Penal Code, Article 145 of the Revised Penal Code, or the violation of the parliamentary immunity. Illegal assembly under Article 146 and direct assault under 148 of the Revised Penal Code. Number 3. So yung kanina, 6 years, above 6 years, disqualified. Except doon sa bagong provision ng batas under RA 1070 and 7. Pangalawa, crimes against national security or the security of the state. Third, those who have been previously convicted by final judgment of an offense punishable by imprisonment of not less than 1 month and 1 day, or a fine of not less than 200 pesos. Halimbawa, convicted criminal ka at ikaw ay nasintensyahan ng less than 1 month of imprisonment. Okay? Not less than 1 month and 1 day of imprisonment, ibig sabihin ay 1 month and below 1 month, you are disqualified. Kasi mabilis lang yun eh. Or a fine of not less than 200 pesos. Those who have been previously convicted by final judgment of an offense punishable by imprisonment of not less than 1 month. Pero under Section 2, Paragraph C of Republic Act 1070 and 7, the new law, amending some provision of PD 968. Ang sabi po dyan, the imprisonment is more than 6 months and a day and a fine of 1,000 pesos. Okay, you are disqualified. Tumaas. Okay? And those who have been once on probation under provisions of PD 968 and those who are already serving sentence at the time the PD 968 was enacted. Do sa bagong batas ay pinalitan lang those who have been once on probation under the provision of 10, anong batas yun? 1070 and 7. Okay? Those who are already serving sentence at the time the RA 1070 and 7 was enacted. Okay? So yun lang yung mga changes. Now, aside from the convicts disqualified to apply for probation, ibig sabihin, hindi ka nag-fall doon sa 5 or 6 na disqualification. Ano pa yung mga ibang mga bagay for you to be disqualified to apply for probation? What are the other criteria that must be taken into consideration? Number 1, under Section 8 of probation rules, every time na mababanggit ng probation rules, yan yung implementing rules and regulation under Executive Order 292. Okay? Probation shall be denied if the court finds that the offender is in need of correctional treatment. So pag nakita ng korte na mas favorable sa iyo na magbago sa loob ng kulungan, then you will be disqualified to apply for probation. Remember, probation is not a matter of right. It is only a privilege for you, and it is a discretion of the judge. Okay, so kung nakikita niya na mas effective sa iyo ang correctional treatment, that you will be incarcerating inside jail or prison, then hindi ka pwedeng mag-apply ng probation. There is undue risk that during the period of probation, the offender will commit another crime. Okay. Paano nila malalaman yan? Malalaman yan during the post-sentence investigation, wherein titignan lahat ng background mo. Ngayon, kung makikita niya na ikaw ay barkadista pa rin, ganito, prone ka na makakumit ulit ng krimen dahil sa environment mo, dahil sa lugar mo, then the judge will decide that it is better for you to stay inside prison than to apply for probation. Thirdly, probation will depreciate the seriousness of the offense committed. Okay? Next, what are the effects of filing an application for probation and receipt of the application by the court? What are the effects of filing an application for probation and the receipt of the application by the court? Number one, the trial court under section 13 rules of probation rules, the IRR, the trial court may, upon receipt of the application filed, suspend the execution of the sentence imposed in the judgment. Okay? So may stop yun, meaning hindi pa tumatakbo yung original sentence mo. Pending the submission of the post-sentence investigation report and the resolution on the application, yung post-sentence investigation report, ito yung isa sa magiging basis ng judge sa kanyang magiging decision. Okay? If the offender will be allowed or he will be denied in his application. Now, the applicant may be allowed on temporary liberty under his bail filed in the criminal case. So, hindi ka na makukulong. Pwede kang mag-bail. In case where no bail was filed or the applicant is incapable of filing one, the trial court may allow the release of the applicant on recognizance, other type of bail, to the custody of responsible member of the community who shall guarantee his appearance whenever required by the trial court. Okay? So meaning talagang ikaw ay bibigyan ng pagkakataon upang hindi makulong prior to the suspension of the execution of the sentence. Okay? Next. What is the process to be observed in applying for probation until its termination? Kanina is application ng probation. Now, nag-apply ka na. The court will suspend the execution of your sentence and then you will allow to file for a bail or to give you a recognizance. And then number two is notice to the prosecuting officers of the filing of the application and comment of the prosecuting officer. So, nasa judge na ngayon yung petition mo, then the trial court may notify the concerned prosecuting officer of the filing of the application at a reasonable time it deems necessary before the scheduled hearing thereof. That is section 9 of the probation rules. The trial court to the judge may notify the prosecuting officers of the filing of the application. Now, anong gagawin ng prosecutor? The prosecuting officer may submit his comments, if any, on the application within a reasonable time given to him by the trial court from his receipt of the notice to comment, that is under section 10 of the probation rules, the IRR of the probation. Now, pagkatapos noon is number 3, na-notify na yung prosecuting officers, and then magsasubmit ang prosecuting officers ng comment niya in case na meron. Then number 3 is the order of the court to conduct post-sentence investigation. The conduct of post-sentence investigation will last for 60 days. Okay? So within 60 days, ang probation officer ay magkakandak ng post-sentence investigation. Under section 11 of the rules of court, the trial court finds that the application is in due form and the applicant appears to be qualified for the grant of probation, it shall order the city or the Provincial Parole and Probation Office within its jurisdiction to conduct a post-sentence investigation that is within 60 days, okay, to determine that the ends of justice and the best interests of the public as well as the defendant will be served in granting or denying probation. Okay? Now, pag natanggap na yan ng PPA, Parole and Probation Administration, through city or provincial parole and probation officer, ano ang gagawin? Within 5 working days from the receipt of the said delegated assignment, the probation officer shall initially interview the applicant if he appeared in the probation officer upon response to the 72 hours limitation given to him by the trial court. Meaning, halimbawa, hawak niya na yung kaso nitong petitioner. Ang gagawin ngayon ng probation officer ay ipapatawag niya yung applicant within 72 hours upon the receipt of the order or the assignment. Tatanungin niya, interviewin niya, okay, para doon siya magsisimula sa pagkandak ng post-sentence investigation. Bago siya lumabas, ang initial nakakausapin niya ay walang iba kundi ang petitioner. In case na itong petitioner na ito ay hindi nag-report within 72 hours period or 3 days, then ang sabi sa batas ay gagawin ng officer ang the best na magagawa niya to locate, to interview that offender, pero kung still wala pa rin contact at hindi pa rin nagpakita itong aplikanteng ito, itong petitioner nito, i-consider siya as an absconding applicant. Absconding applicant. At ang magiging consequence ng pagiging absconding applicant niya ay madi-deny yung kanyang application for his probation. Okay? So yun yung effect. Yung madi-dismiss or madi-deny yung kanyang application for probation. Now, during such initial interview, in case naman na nagpakita, the probation officer on case or the CPPO shall require the applicant to accomplish and sign Form 1, PPA Form 1, or the post-sentence investigation worksheet. And then, the investigating probation officers on case shall conduct further investigation based on the information contained therein. The applicant shall also execute and sign PPA Form 2, Parole and Probation Administration Form 2, which is the waiver cum authorization form. What is waiver cum authorization? A waiver cum authorization is a waiver authorizing the PPA or the probation officer to secure any and all information on the applicant. Lahat ay i-waive mo yung rights mo at pababayaan mo at iaalaw mo ang probation officer na kuhanin lahat ng information na pwedeng gamitin na laban sa iyong application. Okay? So yan yung waiver cum authorization. Pipirma ka dyan and then dyan na magsisimula ang probation officer para sa post-sentence investigation. Okay? So pagkatapos niyan, sa mga susunod na discussion natin, we will continue that. But for now, ay ikakat ko ang ating discussion. And I hope na naging malinaw ito sa bawat isa. In case na meron kayong mga question, may mga unclear sa discussion natin, then we will meet again sa ating mga session, mga klase sa MS Teams or sa group natin para ma-raise yung ganyang ma-brought out yung ganyang mga concern. But today, ay hanggang dito lang muna tayo sa waiver commotorization. We will continue our discussion in probation sa third part ng ating discussion. Again, thank you and God bless sa bawat isa.